Good afternoon. Welcome on in to the afternoon edition of From Day One. This afternoon, we'll have some audio here in just a few seconds. Let me go ahead and see. No, no,
Now we come to our final quick fire
no.
round. Scenes we'd like to.
No, we are not getting copyright strike for that. Just a second. I'm just trying to find us some court. Alrighty. Today, Judge laughs at
Hey
the
guys,
subset, courtesy of our good friend, I'm not Roger, but due to our good friend over at Team
but
Skeptic.
seriously, guys, your help means the world to me. The consultation is free. 1-170-598. Building Credit Management versus Kevin Hurst. Date and time for pretrial. No appearance.
Good morning, Your Honor. May it please the court, Suzanne Strickards, P44018, on behalf of the plaintiff.
And your name, sir? Kevin Hurst. Okay, where are we on this file, people?
Your Honor, we had a pretrial. You opened up written discovery. We did send discovery out. We did receive it back, apparently unopened, indicating there was a written on the envelope itself. It had written, I'm reading here, I do not accept your offer to contract, all rights reserved, UCC 1-308, signed, and then it was a return to sender, Judge.
All right,
So
Mr.
we attempted to do discovery anyways.
Did you refuse to accept the mail? Did I refuse to accept the mail? Yes. Sir, you can't do that. I can refuse to accept any mail that comes to me. And what the fuck does freeze mean? Are you like having a seizure or something? Because you have to be having a seizure to think that writing an edible highlighter on the outside of your discovery packet that you don't accept it is going to get you out of the legal donkey shit that you put yourself in. This is what we're going to do. One of the things she sent you were requests for admissions. If you do not provide proper answers to those requests for admissions, they are deemed to be conclusively admitted. Do you understand that, sir? Yes, Your Honor. Do you understand what I said? No, I don't. All right, here it is. You, by open written discovery in this matter, you have a right to whatever legal position you want, but you do not have your own set of court rules. Among the things that the court rules provide when written discovery is open is that she can send you requests for admissions. Those requests for admissions are in writing, and they must be answered under oath and in a certain time frame. If they are not answered and filed in accordance with the court rules, then they are deemed to be conclusively admitted. You will not be able to contest those things. And that was what was sent to you, sir. And that time to start running those started with the day they were mailed to you. Your Honor, you don't want to accept I'm not even sure. I do not have any understanding of this is my debt or not. And what do you think was in that packet you refused? In fact, not accepting your discovery packet was probably the stupidest thing you could have done, since it essentially means that you'll be heading into trial without knowing exactly what the allegations and exactly what the evidence is against you. They just coming with these allegations. I'm trying to see and verify if it is. When they called me the first time, they should have sent out verified documents stating that the original creditor and who it was, and that I truly owe this debt.
Well, Your Honor, just indicate that we did attach to those.
They already excuse me, I wasn't finished. I'm not gonna have
Please do,
Your
Your
Honor,
Honor.
she cut me off. This is not a clown show. Oh my goodness. One at a time. I can't finish my statement. Don't interrupt me again, sir. Go ahead, sir. Why, thank you. You will speak one at a time. You will not interrupt each other. You will not interrupt me. Do you understand what I have said?
No.
Mr. Hurst. I don't understand anything. Okay, fine. I don't even understand why I'm here. I'm going to mute you. I don't even understand what's going on. Well, that I have no doubt of. In fact, I doubt you understand how to tie your shoes without accidentally eating one of your socks. I'm muting Mr. Hurst, and I will let Ms. Strickards say what it is she wishes to say. Then I will unmute Mr. Hurst and allow Mr. Hurst to speak. Ms. Trickhart, you were responding, Mr. Hirsch.
Yes, sir. I was just indicating that we did attach the account statements, the full chain of title and seller data sheet to the packet. So even though there was no requirement, we did want to provide that to the defendant. And so that was in all of those materials were in the packet that was rejected, Judge.
Well, let's let Mr. Hirsch respond. Okay, so the
Mr.
understanding
Dean.
that I have is that they should have contacted me 5 days after they they should have gave me documents 5 days after they contacted me about the alleged debt. I told them I have no recollection of the debt. I don't even know enough information to admit or deny the allegations to the debt. So if they're accusing me of this debt, I would like to ask them a few questions so that they can verify that this debt even belongs to me. And that's why I refuse to pack it, because I don't know if they're trying to contract with me or not.
Trust me when I say this. Sovereign citizens are financial black holes, and nobody in their right monetary mind would want to contract with you.
I didn't know what it was, so I sent it back. All right, let me explain it to you again. Whatever political views you have, I had no understanding that they were sending me these things. They didn't even tell me that they was going to send me. In the last court date, did they say, or did she say, we're going to send you something? Sir, I opened written discovery. That allows you to serve written discovery. That allows her to serve written discovery. And she did so. If you elect not to receive it, then that's on you. That's the risk, and you bear the risk of that. But I would urge you, and let me tell you, as I told you at the beginning, you have an absolute constitutional right to represent yourself, but what you do not have is a right to your own set of court rules. You may not be frustrated in court rules, sir, by refusing to accept bail. If that's the choice you make, then that's the choice you make, and you will have to live with the consequences of that. I would urge you, sir, perhaps you might want to get counsel, because I don't think you understand the process, and I'm not at all sure you understand the consequences of the choices that you are making. However, as I indicated, you have an absolute constitutional right to represent yourself. I would urge you to get counsel. So I'm going to give you another date. And sir, she is going to do what she does to represent her client, and you're going to do what you do. And if the court rules cut against you, then so be it.
Sounds like a fair deal to me.
Yeah.
You want to fuck your own life up? Go right ahead. Because nobody's going to stop you from hogging all the paychecks at the breakfast buffet. Especially not Judge Robinson, who's going to have a genuine laugh at your expense by the end of this video.
I got a question. They are claiming that this debt belongs to me, but they have to produce all the proof and verify that this debt belongs to me. The plaintiff has the burden of proof, Mr. Hirsch. That's right. So she got to produce the proof that this debt belongs to me, right?
That would be correct, but she probably did in the packet.
Okay. Thank you. All right. I'm sorry, Ms. Rickards?
Your Honor, would it be possible for us to receive a motion date for, say, mid-July?
Nice try.
Let's give him one more opportunity.
You don't
Oh, you want
deserve
me to
it.
resend the packet, Judge?
I want you to resend the packet. Yes, sir. Let me urge you as strongly as I can.
To accept it.
Receive and open the package. Because if you do not, the request for admissions will be deemed to be conclusively admitted. The lawsuit, as a practical matter, will be over. Do you understand what I have said to you? Yeah, I understand. I got a question. Should they have sent me something before they sent me this package since the last court date? Sir, Sir, they're not required. If you think you need some information, you have the right to seek discovery too. But you can't tell them how to litigate their case. So she's going to send me a packet, and I'm going to send her back a packet as well, right? No, you're going to do what you choose to do. She's going to send you again those requests for admissions. Well, you said that we had a conversation before here. Sorry. We had this conversation before. Go ahead. As a courtesy to you, she's going to send you the request for admissions one more time. You will either accept the package or you will not. You will answer and serve the request for admissions in accordance with the Michigan court rules, or you will not. And then, if you do not, then those things will be deemed to be conclusively admitted. If you choose to send written request for discovery, you have a right to do that too. You can send written interrogatory, request for production of documents, and request for admissions. Same as her.
Well, same as her, but not the same, since he doesn't have the 8+ years of law school to help defend his own case. Now that's the end of the first appearance. He
Okay.
finally accepted the package, so now let's go on to the second appearance.
All right.
We are on the record. This is 21-170-598. Midland Credit Management versus Kevin Hurst. Date and time for pretrial. Your appearance.
Good morning, Your Honor. May it please the court, Suzanne Strickhardt, P44018, on behalf of the plaintiff.
And what is your name, sir?
Kevin Hurst.
Okay. All right.
I do hereby reserve all of my rights, claiming none, not to be compelled to perform under any contract or commercial agreement that I did not intentionally, knowingly, voluntarily, or intentionally. I do not accept the liability of any compelled benefit or unrevealed contract or commercial agreement without prejudice.
You're gonna wipe up all those crayons you just spit everywhere?
Is there anything else you want to say, Mr. Hurst?
That's it.
Yeah, that he's
All
an
right.
idiot.
All right. Where are we on this file?
Judge, discovery's been completed. Motion for summary's been filed. We are looking for the court to assign a date.
Okay. Let's get you guys a date, Mr. Hurst. You have the motion for summary disposition filed on behalf of the plaintiff.
Mr. Hurst.
It looks like this.
What's that?
Mr. Paychips.
It looks like this.
Yeah, I'm asking you the person gets the motion for summary disposition filed by the plaintiff.
Do I have it?
Yes, sir.
Yes,
Yes.
Mr. Paychips, do you
So
have
let's
it?
set your date for hearing and we'll move on. Does July 26th, July 26th at 10 o'clock? Does that work for everybody?
Yep.
Yes, Your Honor.
Okay. July 26th at 10 o'clock, we will hear the plaintiff's motion for summary disposition. Sir, if you wish to file and serve an answer to that motion for summary disposition, you must do so within the terms provided in the Michigan court rules. We'll hear the motion July 26th at 10 o'clock. Again, sir, if you want to file an answer, be sure to serve both the court and the counsel for the other side.
Yeah, he's about to serve them some bullshit pate with a side of dumb fuck salad. Okay, so now the fun part that I've been alluding to this whole video.
Oh,
And
you
when
got
I
fun
say
part?
fun, I mean fun for the judge.
All right, the court has had an opportunity to review the pleadings here. I was particularly interested in the request for admissions that was served by the defendant.
Okay.
Request for admission number 3. Does the plaintiff admit and have proof that the allegations against the respondent are true and accurate, with all documentation being verified, signature and seal? These were admitted. Does number 4, does plaintiff admit and or have proof that the statute of limitations has not expired to collect on his late debt? Plaintiff admitted that. Does plaintiff admit number 6 and have proof that the respondent had a meeting of the minds with the Credit One Bank pursuant to the contract agreement in respect to full disclosure, and that said contract contains no elements of fraud by Credit One Bank? Plaintiff admits that. And number 7, does plaintiff admit and have proof that Midland Credit Management purchased this contract from the original creditor and is now the new owner of the alleged contract and of the said debt that is owed? Plaintiff admitted that. So what we have is an admissions by our defendant of the validity of the contract, admission by a defendant that Midland Creditor is a proper party plaintiff. And then we have a request for admission number 8. Does plaintiff admit and have proof that Credit One Bank did loan their credit to respondent and that the respondent is only obligated to pay back in money to Midland Credit Management? Plaintiff admitted that too.
The judge is almost cracking up. Here.
Also note for the record that having reviewed the brief answer to plaintiff's motion summary disposition, first of all, contrary to court rule, is not supported by an affidavit. 2.116G4 says that when a motion for summary disposition under C10 has been filed and served, the opposing party here would be the defendant, may not rely upon his pleadings, but must, by affidavit or as otherwise provided in this rule, demonstrate the existence of genuine issue of material fact. Again, I note for the record, no affidavit was submitted here. I think it's fair to say that the pleading filed by the defendant is somewhat obtuse. I quote, for example, from the third page, the agreed upon proof of claim not served in place of the original account, for it is a conditional acceptance and not the foundation of an action, and does not become an original demand and amount to an express promise to pay the actual sum stated. In his first paragraph, the plaintiff, and I'm quoting again, plaintiff claims that the living soul utilizes an address in his answer, when in fact the address that is used there indicates that the living soul does not live at this address, but is receiving mail there. So the defendant has failed to appear. He has failed to support his brief answer to plaintiff's motion for summary disposition by affidavit as required by the court. The court has had an opportunity to review the pleadings filed on behalf of the plaintiff in this matter, and I'm satisfied. There's no general issue of material fact in this matter. Summary disposition is granted in favor of the plaintiff. If you'd be kind enough to send me your judgment under the 7-day rule, I'd appreciate it.
I literally watched that part like 10 times with the biggest grin on my face, and it just kept getting bigger. All right, guys, that's the end of the video. If you liked it, leave a like. If you disliked it, leave a dislike.
And thank you very much, Father Skeptic. Enjoy your trip through Europe. Again, we'll reach out to you as you continue your trip when you have more goodies to share with everybody. With that, of course, we'll probably have Roger join us in the open night. Until then, thank you for watching. Of course, like, share, and subscribe. Be kind to one another. Sorry. As we march along this afternoon and every afternoon here from day one. Have the best of afternoons. We'll see everybody here bright and early tonight.